Hi, my name is Paul Vuglers. I'm a senior family law lawyer at SBMB Law. Under the Divorce Act, the primary ground for getting a divorce is that you have to have been separated for a period of 1 year. The process is that one of the spouses, whoever is seeking the divorce, would issue an application seeking only to obtain the divorce. There'd be no other claims listed in the application. The application would then be served upon the respondent spouse. That spouse would then have 30 days in which to file an answer. Most people who are served with an uncontested divorce, if the only claim is the divorce and they'd have no objection to the divorce proceeding, will not file an answer. It's by virtue of not filing an answer that the divorce becomes uncontested after the 30 days have expired. So the person moving for the divorce at that time would file an affidavit with the court. No court appearance is required. This is all done in what lawyers call over the counter. And a judge then considers the affidavit for divorce and will grant the divorce if the requirements of the Divorce Act have been satisfied. The primary requirement, as I said earlier, is the 1 year of separation. That's fairly easy to satisfy. But secondly, and sometimes perhaps a little more importantly, the court is now required in granting a divorce to satisfy itself that there are appropriate arrangements in place for the support of any children. So if there are dependent children, evidence must be presented to the court at the time the divorce is requested, satisfying the court that the arrangements in place are appropriate in regards to the federal child support guidelines. If those arrangements are in accordance with the guidelines or can be explained as being appropriate, the judge will then grant the divorce. A divorce order will be issued. It will be sent to both parties by the court. The respondent has a 30-day appeal period from the date of the divorce order. If no appeal is filed, the applicant can then request a certificate of divorce, which finalizes the process. The whole process takes, it varies because there are issues with service at times, and when you are filing with the court over the counter, that process is beyond the lawyer's control, but in general it takes about 2 to 3 months, sometimes a little longer for the process to go from start to finish. Should you have any further questions regarding a marriage contract, please feel free to contact us or consult our website for more information.